Well, thank you for the invitation and for having invited me for this very interesting theme. Of course, the theme of religion and its influence on the formation of nation states is a very vast topic. And when tackling this from a historical or legal historical perspective, one has to make choices. It would be very interesting to talk about what happened after the Second World War, for example, what happened in the 19th century. In the Middle Ages, it's very interesting as well. But I prefer to focus in my talk on a period with which I'm very familiar, which is the early modern period, and more particularly the 16th and 17th century. What I'm doing in my research is more or less looking into the history of commercial law, but there are lots of links to the theme of this webinar, because when one talks about commercial law in the 16th, 17th century, one has to talk about capitalism, about things that are emerging, that are very new, for example, stock exchanges, capital ventures, selling shares, for example, is something which arises in the 17th century in the Netherlands. So things like that are new, and lawyers are grappling with these problems. They have to find new rules in order to address the legal problems that arise. But there is a clear connection with religion, in the sense that lots of the issues that are concerned with capitalist enterprise are problematic from the point of view of ethics and religion. So in the course of the 16th, 17th centuries, one sees a struggling with, for example, usury problems, for example, blind investment in big corporations, so nothing new there. And slowly emerges a theory, a doctrine, which allows for underpinning these capitalist arrangements. And the connection with state formation is also very clear, because in the 16th, 17th century, there was this huge phenomenon of the Reformation, which resulted in civil war, which resulted in countries becoming Protestant for the first time. So the Netherlands, for example, is a Protestant country, which is simply because of the success of the Dutch revolt at the end of the 16th century. And these commercial issues, they became intertwined with state affairs. And so, for example, the city of Amsterdam in the 17th century, the setup of the city was deliberately made very liberal. The idea was that there would not be merchant guilds, for example. Each foreign merchant going to Amsterdam and doing commerce there was considered to be on the same footing as other foreign merchants, even as the merchants of the Netherlands themselves. And this was a deliberate choice. And in fact, in Protestant countries, and I use it plural because it's not only about the Netherlands, but also, for example, about England, there was a climate that allowed for renewal, for new approaches. And it's no coincidence that, for example, the big corporations, the first big corporations of the Western tradition were the Dutch East India Company and the English East India Company. They were both established at the beginning of the 17th century. So what I want to do here is to give you a glimpse of my work, to show you what I'm doing and how this connects with this theme of the impact of religion on the formation of states. So let's first look at what is happening at the beginning of the 16th century. The 16th century is actually the first century of globalization. At the end of the 15th century, the American continent had been discovered, and this resulted in a scramble for land, competition amongst different countries. and also an influx of silver, which was found in newly tinted clay. And this resulted in high inflation in Europe, not only continental Europe, but also in England. And this had a very fierce effect on social relations. One can imagine that if prices are going up and salaries stay more or less stable, that this results in shortages. People were really struggling to pay for their food in the 1510s already, but this becomes really urgent in the 1520s. And this had an impact on state formation because in the 1520s, there was a big uprising in the German territories, which has come to be labeled as the Peasant Wars. And the Peasant Wars were a revolt that was based on the idea that there had to be social reform. And so you had peasants urging, for example, for tax cuts, so a very modern idea. They were also reacting against the clergy because the clergy was really considered as an extractive force. They were raising lots of taxes, the tithes, part of the harvest of the yearly yields of the agricultural businesses had to be paid to the church. And in the course of the Peasants' War, there were claims to have the clergy reformed and to give, for example, the people the power to depose clerics of a certain constituency. So the idea that the clergy had to represent the interests of the population was for the first time mentioned there in the 1520s. The 12 articles are a very interesting text. If you want to know more about that, you can easily retrieve that text. Martin Luther was responding to what was happening in the German lands. In the 1510s, he started to write about social unrest, social problems, theological problems, and the attitude of the church, of the Catholic Church. And he blended that easily with ideas on the economy, on the political economy. For example, in 1519, he wrote a treatise on usury. And this is a very interesting text. I would recommend it highly. It is a sort of make Germany great again in the 1510s. And it's all about how to reset society and how to do so in a way that is not at the expense of the lowest classes. So he reacts very much against the actions of the elites, of the merchants, of the nobles as well. And he focuses on what is acceptable from a theological perspective, acceptable in trade and in credit relations. So he, for example, says it is not something which a good Christian does to ask interest on loans, for example. Loans have to be gratuitous, they have to be a favor, and they do not have to be compensated by the ones who get the money, because the people who get the money, they will need it to sustain their households. So Luther is really blending different phenomena, different things that are happening at the same time, the social unrest, reacting against the attitudes of the church, and also the economic arrangements, the rules that relate to contracts that are signed on markets. In the 1510s, 1520s, for the first time, there are stock exchanges. The earliest one is the one at Antwerp. And there is a widely dispersed feeling in society that what is happening there is not a very good thing. There is a lot of speculation going on. And when starting in the 1530s, the speculation is also concerned with grain imports, then it becomes really problematic. In fact, in the beginning of the 16th century, lots of countries were dependent on grain imports. And there had been a rise in population in the 15th century. So it was simply impossible, for example, for large regions of France and for the Low Countries to be self-sustaining. So they had to import grain mostly from the north of France and later on also from the Baltic regions. So once speculation trickled into the grain import and grain trades, this became really problematic. And some legal issues were very much linked to that. For example, the question as to whether a monopoly is lawful, whether it's acceptable to give a license to one trader to import grain, and whether this is not something which allows for fraud, which is an incentive for fraud. And there were lots of rumors about these big merchants importing grain who were actually storing grain themselves and waiting until the prices were high enough to sell it, things like that. Closely related there to bankruptcy as well. The capitalism is new in the 16th century. Bankruptcy is very much related to capitalism. How does one approach merchants who cannot pay their debts? And at first, bankruptcy is considered something which is not done. Any bankrupt is presumed to be a fraud, to have tricked the creditors. But over the course of the 16th, 17th centuries, as I mentioned, slowly a doctrine emerges that underpins the idea of a good bankruptcy, the idea that one can that one can encounter some circumstances that are not wanted. For example, if you have a ship arriving with your merchandise and the ship sinks, well, then you cannot sell it, you cannot generate profit in order to repay your debts. So that would qualify as a situation of good bankruptcy. In the writings of the theologians, of the Protestant theologians, in particular Luther and Melanchthon, there is a lot of reflection about the usury problem, monopoly and bankruptcy in reference to Catholic theology. The scholastics had been writing about these things since the 12th century. And Luther is really engaging in studying the writings, in particular of the school of Salamanca. Those were theologians who were working in Spain. And they were really trying to find a compromise between the newly emerging capitalist techniques on the one hand side and the tradition of scholastic theology. And Luther is very much against that. Luther is very controversial in the sense that he wants to get rid of this scholastic tradition. The term scholastic gains a bad connotation for the first time. That's because of Luther's appraisals. And he wants to get rid of that. He wants to return to the core of faith. He wants to return to the idea that loans do not have interest, that monopolies are not allowed, and the bankruptcy is bad, basically. At the same time, a few decades later, you see that Calvin is writing about the same issues as well, and he takes another approach. That's a big difference, big distinction there in this broad group of Protestant thinkers of the 16th century. You have Luther and Melanchthon on the one hand side, very fierce, very critical, very radical, one would say. On the other hand side, Calvin, who is trying to recover this scholastic theology. For example, he accepts usury, which he does not call usury, of course. He accepts interest for commercial loans and even high interest rates, because he considers this an element of consent. So if you would engage in a loan and if you would agree to pay a certain amount for that, then this is completely fine, that this is completely in line with theological thinking. Hovering in the background, looming in the background, is always the problem of predestination. Luther, for example, he stated, well, predestination is not absolute in the sense that faith is really the way to gain access to heaven. If you understand what the teachings of Christ are, then you can gain access to heaven. Whereas, for example, Calvin is very strict and says, no, this has been predetermined. So man has no part in that. And in an odd way, the theology of Calvin is actually considered beneficial, interesting for middling groups and also for merchants. Because if you have success in life, then this is actually a sign of the fact that you were predestined, that you will be given access to heaven after your life. So in an odd way, Calvin is actually supporting, with his theological thinking, supporting the nascent capitalism in the 16th, 17th centuries. Very briefly, the civil wars, the main results of these wars in different parts of Europe was that some countries became Protestant, others remained Catholic, and the divide between Calvinism and Lutheranism was there as well. The Netherlands became Calvinist, whereas Scandinavia and large parts of Germany became Lutheran. And then you had the odd situation, the odd example of England, which became Anglican, and that was a mixture between Lutheranism and Calvinism. The tolerance is an important part. You have the influence of religion on state formation in the sense that the Protestants, they want to get the rights to practice their religion. They want to have equal rights. They want to be treated in the same way as the Catholics are. And lots of the civil wars, they emerge, they start off from the claims by Protestant elites often. In the Low Countries, they were certainly high members of society who wanted to have a freedom of religion. They wanted to have the right to have churches, to have Lutheran, to have Calvinist churches. And in the Low Countries, which was under a Spanish rule in the 16th century, this was blocked off. It was simply refused that there would be any other religion practiced there besides Catholicism. This theological link is also important in the sense that ever since the beginning of the 20th century, the idea that Protestantism has a connection with capitalism is very prominent. And this is the result of a very famous theory by Max Weber, who used the theology of Calvin to say, well, this theology of Calvinism has created a mindset which allowed to have more investments, which allowed to have these capitalist contracts, these capitalist techniques become widespread. And that's why economic growth was much more important in some Protestant countries in the early modern period as compared to the Catholic countries. And the cases in point there are not only the Dutch Republic, but also England, which in especially in the 18th century becomes a world power. Now, in my work, I'm really zooming in on these problems. For example, bankruptcy. It's indeed true that in the Dutch Republic, it became much easier to go bankrupt. There was no stigma after 1650. So one could simply, if one did not have the capacities to pay debts, go to the administration of the city and ask for a clean slate. And then all creditors were invited and they had to accept cuts on their debts. They had to accept that the debtor could not repay the debts. But this is something which is not exclusively happening in the Dutch Republic. It is happening in other countries as well, even though in the Dutch Republic, the regime, the legal regime, goes farthest. So this is the most extreme variety of this approach, but one can find ideas on the distinction between good and bad bankrupts in 17th century, for example, in France, which was an important Catholic country. The idea that Protestantism had an impact on economic growth is, to a large extent, a bit of a false variable for the main reason that the novelties that were happening in the Dutch Republic and also in England, they did not have a lot to do with Protestantism as such, but rather with the fact that because the civil wars, because the emergence of freedom of speech, freedom of religion, had changed the constellation of the state, it became much easier to do new things. And these new things were not directly connected to Protestantism. There was no such thing as a Protestant idea of the stock exchange or a Protestant idea of a corporation. But because there was this climate of change, there was this climate of innovation, it became possible to do new things. And this was less the case in Catholic countries. For example, in Catholic countries, the guilds remained very prominent. And the guilds were sort of medieval structure that channeled expertise, but which was not very innovative anymore in the 16th and 17th centuries. So these guilds were actually blocking innovation. They were rent-seeking institutions. They simply tried to capture the largest share of the market, and they did not want to have the best products in the market. So they had different incentives. For example, in Amsterdam, one can see that there are no merchant guilds. And this is a deliberate decision. So there is a decision to have an open access so that all people, all traders can come to Amsterdam. They can trade, they can be served in their own language. They can practice a religion of their choosing. This is accepted, and this is even facilitated. So there are notaries working in Amsterdam who can draft contracts in different languages. The municipal administrators of the city, they also judge cases on several different issues, some foreign, some not. So there was no real distinction there. And there is also a preference for clubs, and this is a new institution. And a club is very different from a guild. A guild has a high entry bar. There is a threshold to enter, so you have to pay for that. You have to study for several years. You have to make work that is accepted, and then you are accepted as a member of the guild. And after that, you remain member for the rest of your life, irrespective of the quality of your products, irrespective of your behavior and things like that. So it's a very closed environment. Clubs, by contrast, are different. And the club-like setting one can find, for example, in the Dutch East India Company, the early 17th century, in the English East India Company as well. So there you had the idea that people could invest, and these investors, they were invited to bring their money for certain expeditions. For example, if a new island had been discovered in present-day Indonesia, for example, then in Amsterdam, in the premises of the Dutch East India Company, a meeting could be started, and people could be asked to invest, and then a ship was equipped, and staff was sought for that ship, and then the ship sailed to the Indies, And after 2 years, it returned with spices, and these spices were sold at very high prices, and everybody made a profit. So this is very different from guild, because it's always for a venture. Right? It's always for one specific project. And this allows for checks on the people who are cooperating, who are investing. Because if someone invests and does not pay up, or for example, if someone volunteers to sail on the ship, but it is clear that this person does not have the expertise to do so, or if this person goes to the Indies and steals spices for himself, then it is very much possible that in the next expedition, this person will no longer be accepted. And this allows for a sort of cleansing effect. It's possible to have renewal in personnel in members of these clubs, which was very different from what was happening in the guilds in, well, let's call it the Catholic countries, the countries that had not had not gone through this turmoil of civil war, and had not in the end have this new climate of innovation and tolerance. In the end, this was also connected to the idea that officials, administrators, were not so much elected. The idea of election is still not very important, but that they had to account for their actions, and that if they did something which was not acceptable, that they could be deposed, that they could be changed, and that someone else could take their place. This was very prominent in the corporations of the Dutch East India Company, and especially in the English East India Company, where he had the idea that commissioners, the ones who were responsible for keeping the books and for paying wages and things like that, they could only be in office for 1 year. And after 1 year, they had to show, they had to demonstrate what they had done. And if the meeting of shareholders was not too happy with that, then this person was replaced with someone else. So this created a climate which in the end would result in parliamentary democracy. And parliamentary democracy, first signs of that end of the 17th century with the Bill of Rights, where the English Parliament is considered the most important institution, and where for the first time it's said that Parliament has a check on government, so that administration is not something which can be unlawful, that the laws are there in order to determine what may happen, and that Parliament controls the ministers in what they are doing. Okay, so that was more or less what I wanted to tell you. So in a nutshell, the influence of religion on the formation of states is quite haphazard. There is no direct link. One cannot distill the Protestant characteristics in the constellations or the constitution of certain states, for example, but there is a link in the sense that the way in which Protestantism got accepted in the course of the 16th and 17th centuries, in some countries and not in others, created a sort of climate which had an impact on, in the end, the constellation of states. So that was my lecture. I hope you enjoyed it, and I'm looking forward to your questions. It's interesting that you mentioned this, even though I'm not too familiar with Islamic law and especially, well, the interest question there, which has a big parallel with what is happening in the Middle Ages. The usury doctrine has some very interesting links with ideas that are present in Islamic circles. So it would be an interesting topic, but I don't think that I can really give you some examples, for example, about this connection between the social unrest, theological problems, and the rising capitalism, which would then have an effect on state formation in Islamic countries. But maybe Gitanjali knows more about this because she.
Yeah, it's a very complex question because the Islamic world is very big, and there are certain kinds of Islamic concepts which you can see in the context of trade and commerce. There are certain concepts like the waqf, for instance, which is a device for holding property. But this is very complex and it varies across the Islamic world.
It's a good question. If I recollect well, these are rules with regard to carriage of goods, right? Mostly sea transport. I don't think that there is an influence there. From what I know about present-day maritime law and, well, public international law with regard to maritime law, it is very clear that there is a high influence from US law. For example, one of the recent Chinese codes was a maritime code, and it was largely influenced by US law. So I imagine that there is a lot of harmonization in that respect. And I don't think that the theme itself is very apt for influence from religious differences, but maybe you could clarify what you had in mind. Well, that's an interesting question, and it's a bit of a cliche, right? That the Protestants are very parsimonious, whereas the Catholics they spend a lot. They don't really care about the accounts and the books and things like that. I think there is indeed, well, there is a link, especially with regard to Scandinavia and Germany, probably as well, where you since the 19th century had a very elaborate administrative science where you could actually study the management and public administration. And a lot of emphasis was put on diligence and on being very careful when acting with public budget. So I think that indeed there might be some sort of very deeply underlying idea there that is very typical of many Protestant countries. Well, in the 16th century, state debt is, of course, not really a problem because there is no welfare state. There is not a lot of public expenditure unless when it comes to the military, and the taxes are raised primarily to pay for that. So the idea that public debt is in the end something which has to be paid by the public is very modern. So one cannot find it in the 16th century. But there are some links though, especially in Calvin, on the administration of the household budget, for example, that one has to be careful, that one has to take the interests of all the members of the household into account, that one cannot be a spend thrift, things like that. That's something which one can find in the Protestant literatures. So I think deep down there might indeed be some element there that has been passed on from history to the present day.
So I'll begin now with my talk, which is to do with the impact of religion in India. And I will talk about, for instance, how India was formed as a nation state and the colonial conception of religion and how it has influenced the making of India as a nation state. Now, there are three aspects to this talk. I'm going to speak about the relationship between religion and law and how this has affected the attitudes of the British colonizers in India. The second aspect is how this has actually impacted codification in India and the enactment of separate Hindu and Islamic laws. The third aspect will be how this has affected contemporary law. Let's begin with the relationship between religion and law. There are two aspects to this. One is the relationship between religion and the state and how the state chooses to define religion. Now, we know that in the European context, there have been a lot of restrictions about having religious symbols in a public space. For instance, on Muslim women wearing headscarves in the areas of employment and in education. This involves both teachers and students, and also representations of the crucifix in classrooms. There's a very famous case in Italy about this. Now, how does the court actually look at this in the context of law? It assumes, for instance, that the act of wearing a headscarf or placing a crucifix in the classroom is an act of carrying out one's belief in a particular religion. So they assume that there are various symbols which represent religious beliefs, and that these beliefs are represented in religious texts. Now, the Muslim woman wears headscarves because there is a specific commandment to do so in the Quran, which is the authoritative text for Muslims. Now, this kind of symbolism is very characteristic of Western thinking about religion across centuries and is modeled on their own experience of Christianity as a religion. This was also true in the context of the European colonization of other countries, where they met other civilizations that did not have writing systems. They assumed that religion was in practice and it was not in text. However, India was very different because of the presence of systems of writing and sophisticated literature which influenced the population. There was also the presence of a very vibrant market economy and political system, including the Mughal Empire, which was a Muslim empire, and other various kingdoms who traded with the rest of the world in products such as fabrics and spices. Now, how did the colonization of India happen? European powers were present in India from the 15th century, the Portuguese, the French, and the Dutch, arriving mainly in the form of commercial companies and setting up forts and settlements in order to trade with the local population. However, the British were the most successful in establishing territorial control. It's very important to understand that these commercial companies functioned like governments. They had armies, navies, and signed treaties, and they carried out administration and levied taxes. They had the capacity to act like states. The commercial company that acted as a vehicle for British expansion was the East India Company. And they've just mentioned and spoke about the role of companies in global trade and commerce. The East India Company came to India mainly to trade, but in order to trade, they had to establish permanent bases in order to extract resources and facilitate the sale of products. So what they did was they established territorial control, and I'm going to show you a chart which basically looks at a timeline from when they were here, and this stretches over nearly 300 years. Right. So the time period of colonization was from 1600 onwards, when a charter was granted to the East India Company by the British Crown. And this, after 100 years, another another grant was made of 3 villages in Bengal by the Mughal Empire. And in 1727, courts were established. In 1757, there was something very famous called the Battle of Plassey, where the Mughal Empire was defeated by the British Crown. And this led to the East India Company establishing control over the entire Indian subcontinent. So this is a span of nearly 200 years, and it took almost 200 years for the East India Company to establish itself. Initially, they were a trading company, but they became a territorial power. And after 1757, they tried to establish themselves over the entire Indian subcontinent. And by 1857, when the Indian Rebellion took place, they controlled the entire country. So it was in the last century of the East India Company where they really started to face problems of governance, and they had to decide how to govern the population and what kind of law they needed in order to govern the population. They saw religion, for instance, as being very crucial to governance. And what was the reason for this? This was due to the fact that they did not see the political system in India as being a good system. It was considered to be corrupt and despotic without the safeguards that were present in Europe. They considered their own political system as being superior. And we need to remember here that there's a struggle to reduce the powers of the monarchy in Britain during this period. And the system of cabinet government had come into being, and the monarchy did not have much power. And they did not have much respect for monarchies in the context of seeing it as a concentration of power. They were also very sure that imposing their own legal system would not work, as they thought that the legal system of Indians was very deep-rooted, and it was not possible for the English common law to take root. They applied a lot of ideas that was common in Europe, such as that of Montesquieu, saying that the climate influences the way Indians think, and that Indians do not have a conception of consent or free will, which is important for the application of common law principles. Instead, they tried to identify the law of the Indians themselves, and they perceived such law being in religious texts called the Dharma Shastras. They expected these texts to have a system of law, and these, however, were texts that only prescribe ritual, and they did not have any law. And since they could not find out what a law was, they tried to translate many of these texts in order to find the law. And they got a scholar known as the Pandit in order to help them understand the law, which they could apply to resolve the dispute. This was not very satisfactory, and it became a problem as these scholars did not give consistent opinions, and they found it very difficult to arrive at any application of law consistent with the doctrine of precedent. The reason for this was that there was no such thing as law in the way the British saw it in these particular texts. Law was mainly based on customary law, and resort to textual sources was only done if custom did not provide an answer. Custom itself did not have clear categories such as property or contract, and there were no written records of how disputes were settled. They therefore selected certain aspects of the translation which was relevant to their governance, particularly the law of property and marriage and succession, because it was very important for them to know how property ownership was taking place, as they had territorial control and were effectively sovereigns. Although many East India Company administrators were in favor of applying local law, there were others who did not feel the same way. One of these administrators, Charles Grant, was an evangelical Christian, and he argued that the East India Company should not be supporting a pagan religion or religious practices. This did not have much effect, and a company continued to govern according to religious law, although they stopped regulating certain areas such as religious activities or religious practices. They continued to govern Hindus and Muslims according to a particular regulation known as the Administration of Justice Regulation. And the codification of these various laws, the Hindu law especially, was done as part of carrying out this kind of regulation. They also tried to codify Islamic law, which is something that I'll come to in the latter half of this presentation. But many of the attempts in governments of India resulted in a lot of disaffection among the population. And there was a rebellion in 1857, after which the British Parliament directly took over India. It took over the East India Company's powers and began to directly rule India. And this is when the system of the codification of law really began. Otherwise, you had a lot of digests and translations of this law and judges giving judgments on the basis of this law. But the codification in terms of statutes or enactments was not really there. So the British Parliament found the system of law very unsatisfactory and decided they would come up with a new legal system which would be based on the common law. They began a system of restructuring and instituted new courts which gave judges the power to come out with judgments without reliance on scholars of the religious texts. This emphasis on codification had two aspects: a focus on building secular systems of law and also retaining the religious law of both the Hindus and the Muslims, which was left uncodified. The British decided to come out with a number of statutes covering most areas of law on property, contracts, and commercial law. They also codified criminal law. And they, however, left the family law intact, as they still needed to know how succession to property was carried out. And the laws of marriage and succession complemented these various areas of law, thus allowing for a complete legal system. The second aspect was how to ensure that these inconsistencies in religious law were dealt with, as the experience of using scholars of the religious texts who were native Indians as a source of law was not adequate. So this was done by rejecting the idea of looking at religious texts and focusing on customary practice. However, these customary practices had to be subject to religious texts because they had to have an origin, and the British were not willing to accept customary practices as standalone practices. In reading cases, judges would take evidence of the customary practice from individuals and then try to see whether these practices were in conformity with any of the books that they had translated, and which had specific categories such as marriage, property, and succession. They also subjected customary practice to common law tests, such as the length of the time the custom was practiced, the consistency in practice. There had to be no breaks or changes. It had to be reasonable. And most importantly, the customary practice had to be moral in nature. This led to problems, as the conception of morality was very subjective. And this led to many customary rights to land being rejected, as well as ritual practices certain practices in temples and in places of worship were not allowed to be carried out because they were considered immoral. And there are many other practices relating to families, such as matrilineal practices or tracing inheritance through the mother. Those kinds of practices were not recognized. How did this affect the practice of Muslim law? The British codified Hindu law, and they had many problems in identifying religious texts, but they were very well acquainted with Islam, and they knew that the core religious text of the Muslims was the Quran. However, they were not familiar with Islamic law or its methodology, so they assumed that all Islamic law was merely a reproduction of the Quran in the same way law made by the king or parliament was reproduced in the works of judges or jurists. In order to implement Islamic law, they started to collect various legal opinions or fatwas issued by Islamic jurists and reconstruct them into a system of law. They had a very negative opinion of Islamic criminal law because they saw it as being very arbitrary. And this was one of the reasons why they decided a new legal system was necessary, because the Islamic system, which was there, was not working properly. The Mughal state was not functioning properly. They ran into the same kind of problem that they could not find any law on property ownership and family law. These areas of law were very important for them, and they were not unable to find it in Hindu law, and they were not able to find it in Islamic law either. Now, it was really not the case that there was no property law or laws regarding ownership in Islamic law, but the British did not understand the methodology of Islamic law. And this also brings us to the question of why they were so obsessed with the idea of family law. And this was mainly due to the fact that they had to distinguish between the areas of public law and private law. During the 19th century, the European jurist Savigny was very influential upon many judges and jurists in England. And he saw family law as being a special kind of law which reflected the character of a nation. And family law had to be distinguished from private law, which was about secular aspects of life, such as the right to contract, sell, or buy. Now, the British had problems with Islamic law because certain aspects of family law are contractual. Marriage is considered a contract, and very often property is exchanged during Muslim marriage. It became very important to distinguish between what was public and private because the British saw themselves as inheriting the power of the Muslim Mughal Empire, who had given them the grant to govern Bengal. Since they considered the rule by Mughal rulers despotic, they did not want to be seen in the same way. They wanted to show that they had security in property relations, which was absent in the Mughal Empire. And this was only possible by having private law, such as the law of contract or sale. Another problem in the codification, or rather the consolidation of Islamic law, was that the British assumed that there was a unified Muslim community and that there was also a unified law. This was not true, as Sharia was not imposed on non-Muslims, and regulation was extremely local in nature prior to the British colonization of India. Under the Mughal Empire, there were local functionaries and local bodies which implemented local law. There was no appeal procedure unless matters were really serious, such as a disturbance of public peace. This also led to a problem because there were several Muslim communities with their own customary practices who did not follow the Quran in a rigid manner. Assuming that there was a unified community was very problematic due to this, due to these very different communities. Many of these communities followed inheritance practices which were not on the basis granted by the Quran. And the Quran granted some property rights to women, but these Muslim communities did not grant any property rights to women at all. They totally disinherited women. Once the members of the community realized that courts were trying to implement succession law according to the Quran, they filed cases in court stating that the Quranic rules should be implemented as the customary law was discriminatory towards women. This created quite an uproar because the courts noticed the number of cases being filed, and he found it difficult because there was a presence of a custom which was against a religious text. This created problems for the British because you could not have a standalone custom which was violative of the source of law governing the community. Their legal system could not accept standalone customs. To remedy this problem, the British passed a law known as the Shariat Act in 1937, which ensured there would be one Muslim law that would govern all Muslim communities. This had the support of some Muslim lawyers who were trying to make the demand that Muslims be considered a separate nation. The debates about the codification of family law played a very important role in organizing Muslims as a political community. This, unusually enough, was in line with Savigny's arguments that the family was a form that was distinctive to a nation. How did the formation of Hindu and Islamic law affect the formation of nation states? The increasing legal consciousness of being governed according to religion also had an effect on politics. Political parties based on religion emerged. This resulted in the partition of the Indian subcontinent into the modern nation states of India and Pakistan. What was the colonial legacy of these laws in India? Due to the violence wrought by partition, many people wanted to ensure that there was no religious law in the new republic. So they put a clause in the new constitution saying that a common civil code for all its citizens should be created by future parliaments. However, there were many challenges to this because the Muslim community in India wanted to keep its laws. There was also a demand that these laws were not progressive enough and it violated many principles in the constitution, which led to demands for reform. So it is very unusual that the constitution came out with the idea that there should be a uniform civil code and there should be no laws which are religious in the country. But one of the first things that the newly independent Indian state did was to try to codify the Hindu family law in the form of statutes. Polygamy among Hindus was abolished, and other aspects of succession and inheritance were legalized. Certain mechanisms, such as a conception of the joint family, which allowed entire families or kinship groups to hold title to property collectively, were also enshrined in law. Muslims, however, argued that their law could not be subject to regulation by the Indian state. So Muslim law was left uncodified. This became very controversial, and there were many debates on how Muslim law violated the constitution, and there were also other practices such as polygamy in Muslim law, which had been the subject of reform in Hindu law. The Indian state made an effort to legislate on certain aspects of Muslim law, but the large part of Muslim law has been left uncodified. The legacy of colonial law continues in different ways. The selective way in which Hindu law was codified had an impact on how religion is perceived in law in India. As one mentioned, customary practices were important in law, but texts perceived to contain religious rituals were considered important as sources of law. This is based on a conception of symbolism that religious beliefs of the people were related to a set of texts which were considered to be similar to the Bible or played the function of the Bible in Christianity. Unfortunately, there are no set of core texts within indigenous traditions in India. But what has happened is that in settling claims made by Hindus on religious freedom, the Supreme Court of India uses the same logic as British colonizers, trying to deduce whether religious practices are reflected in a set of texts. Whereas the British had a logic in trying to identify these texts as religious in order that they can govern India, there is no logic in the Supreme Court doing so. The result of this is that there is no clear test to determine what is religious freedom, and practically all practices become worthy of being protected as religious freedom. This has resulted in a number of claims before the court, and it has also resulted in the consolidation of the idea that religion is key to governance and that religion governs every sphere of life. This can be witnessed in the political sphere, where the current government tries to relate everything to religion, including practices in relation to food and medicine. Within the Constitution, there are specific provisions relating to not slaughtering cattle in order to discourage people from eating beef, which is considered a religious Hindu practice. This affects communities that eat beef. There's also special funding for systems of medicine, which are considered as related to Hinduism. So I'd like to conclude by saying that in the context of the formation of nation states and the impact of religion on nation states, the Indian state has inherited a colonial conception of religion which influences the manner and the way it formulates governance practices. And this often becomes a problem because this conception of religion is very artificially created and is not based on any kind of sound legal reasoning. And it also has an impact on secular spheres of life, such as land and property and other kinds of systems in the context of the country as a whole, other spheres of life. So, for instance, the slaughter on cattle affects people who deal in beef or who deal in a manufactured beef, and they are mainly Muslim communities that do so. So this contributes to an overall polarization in the governance of the country. So I will conclude there, and I look forward to having questions. I hope you've enjoyed the presentation. Thank you. That's a very complex question. And as I did mention that this entire governance by the British led to a lot of political consciousness. And this resulted, for instance, in the idea that there are separate Hindu and Muslim nations. Although this is actually a very foreign conception, the idea or conception of nationhood in the European context was not really there in India. So this has affected the Indian state, and for the first time, we have this law which is grants citizenship on the basis of religion, and it is completely unconstitutional because this was not what the founders of the Constitution actually wanted, and it is not something that is actually even legal. So I am looking forward to seeing the court's decision on it. I mean, many of these matters are still pending before the court, and I do think that this law will be struck down. About the time before the British arrived, there were these local laws, and it's difficult to understand them as being Hindu or Islamic law because it was mainly customary law, and it was mainly related to the law of the place or the law of the locality, and it wasn't related to an overall text as such. And the Sharia as such was implemented only in the metropolitan areas and by the Mughal Empire itself. And they did not really impose Islamic law throughout the territory because it would be very difficult to impose it, as the country is very big. There's a lot of variation in population in terms of social groups, many languages, many customs, many cultures. So it would be very difficult to do so. The idea or this conception that there are two separate religious communities, which are Hindu and Muslim, is something that comes in only during the time of European colonialism and during the time of the British, and it's to do with the administrative methods that the British came up with. And this kind of coexistence as such is not really a question, because during the British period, this was done by judges, and the judges came out with decisions. And even in independent India, the judges are the ones who come out with decisions. You do have certain informal systems of Islamic law, such as legal opinions given by Islamic jurists and who study the Islamic law in a traditional manner. But that is something that's not really recognized by the Indian state, but it has a lot of credence with the population. And you also have many other local ways of deciding customary law and deciding local disputes on the basis of customary law.
Actually, and my question is actually addressed to both Dr. Geetanjali and Dr. Dave. So really what my question is the purpose, well, one of the purposes of this seminar is, it was kind of to get to experts such as yourselves to come and speak, but to also maybe offer those of us who are interested in pursuing a career in legal history. Could you perhaps give us some advice or some insight as to how you proceeded when making such choices?
Well, I would like to start. It's quite a tough market, but this has to do with the fact that academic jobs are quite rare to find, especially in legal history, since, well, we do not have several chairs, for example, per university. At most there is one, so it's always a bit of luck involved as well. So you need to find a vacancy and open post. But I would recommend, if you would be interested in pursuing academic research on legal history, that you focus on the writing essays, that wherever you have the chance to pick a subject, that you take a legal history subject, and also that you get into contact with the legal historians of your university as soon as possible, because they would be very interested to know that you are looking for an opportunity to do academic research. So that would be my advice.
Okay, regarding doing legal history, I think it's often also important to see that legal historians can have a place or a position in other areas of law as well. So my advice is also to concentrate on areas of law that you find interesting, and perhaps focus on the legal history behind these areas. And this is due to the fact that legal historians, as I mentioned, don't have to be necessarily in departments of legal history. They could also be in political science departments or in history departments, or they can also teach or practice mainstream law. And I think it is becoming very relevant these days to do legal history, because I do know, for instance, now with the recent pandemic, many governments are trying to look into their archives to find out how they how they dealt with the 1918 Spanish flu. And there are many reflections by historians all over the world as to how this particular pandemic is different or similar to the 1918 Spanish flu. So there is a lot of scope in legal history, but it's probably more advisable to do it as part of mainstream law in the context of job opportunities, since, as Dave mentioned, there are very few chairs for legal history. That's actually quite a vast topic, and there is this entire movement towards social reform where there have been many reformers who tried to basically come out with some kind of answer to the British in the context of what they were saying about various practices like sati, etc. So this is something that one perceives, but I think the conceptualization or even this question about women and being the forefront is also to do with certain kinds of attitudes about gender and sexuality, which the British brought about to India. And also the fact that they could not really understand how property relations or how Indian law really worked, and also Islamic law. Because many colonial administrators were often very surprised that Muslim women had property rights, because at that time in England, women did not have property rights. They were basically chattels of their husbands. They were their husband's property. So they were very surprised with that, and they still considered Islamic law as being inferior, but this was something that astonished them, and they could not actually believe it.